Delegate Rob Bell.
I had a chance to meet almost all of you at some other event, but thanks for having me back. I have Thomas Jefferson's seat in the General Assembly. I represent Albemarle County, and it's just an incredible honor. And the reason we all love Mr. Jefferson is not because he toppled the king, because that had happened many times before. The difference was that when he got done, he didn't put a new king in his place. And so the reason he's a hero for Tea Party groups is that it was his idea, along with Madison and Washington and the rest, to come up with a constitution of limited powers. And then you have the additional protections of the Bill of Rights to protect you. And so that's why I think all of us revere his work and why he's kind of the most important man, arguably, of the millennium. He had some quotes, and we already have a Jefferson quote, so maybe this is duplicative, but he has one I always take to the Tea Party groups. He said, Mr. Jefferson, "When angry, count to 10 before you speak. If very angry, count to 100. Well, I think most of us have counted to 100. We're still angry. So, what I want to do is talk about how we ended up with this constitutional amendment, what the issue was, and it really relates back to the Constitution itself. So this is obviously the Constitution. Most of us have one of these nearby. Your property rights are protected by the Fifth Amendment, and it's as clear as it could be. It says, "Nor shall private property be taken for public use without just compensation." For public use and with just compensation. And for 2 centuries, everybody knew what public use meant. Public use meant the public could use it. This is not, there are complicated parts of the Constitution. This is not one of them. It's a road you can drive on. There's a school, the kids can go to it. There's a police station. These are public uses. And what happened was there was a series of Supreme Court cases culminating in the Kelo decision where they switched public use to public purpose. And that sounds like a very technical lawyer's problem. Use, purpose, use, purpose. It's not. Public use means you can use it. Public purpose means whatever the politicians want it to mean. And so in the Kelo case itself, what they came up with was it'll increase tax revenues, it'll mean more jobs. Let's just take Horst Suzette Kelo's house and give it to Pfizer. And they did. And everybody thought that that case would never be this is finally the instance was too far, it'll never come back. And instead the Supreme Court said that's okay. That's a public purpose. And ever since then, some of us in the General Assembly have been trying to give you back the rights you thought you already had. And that's what the Constitutional Amendment's about. In 07, we tried in 06, we actually had a bad bill in 06. Thank God it was killed. It would have ruined everything. We were able to kill it. 07, we got the law changed. We tried to get it in the Constitution. My amendment failed. Tried again in 09, failed. Tried again in 10, failed. Tried in 2011, Johnny Joanno, who's a Democrat from Portsmouth, very bravely decided to take this on and help us. And he's the hero of this, because without him, I'm not sure we ever would have passed it. It got to the Senate where they'd always killed it. It got out by 1 vote. Now, to get an amendment to pass, it has to pass 2 years in a row. So even then, we weren't really sure this was going to work. We passed it by 1 vote the first time. We say, uh-oh, they'll find somebody to kill it in committee. Amazingly, it came out the second time by 4 votes. And then it's got to come to you all. The way it works is we pass it twice the exact same way, which is what Waverly was talking about. You can't change 1 word, 1 comma, 1 anything. And then it comes to you all, and you get just an up-down vote. And if you pass it, it'll be part of the Constitution. If it fails, you'll never see it again. We have traded votes, arranged committees. We had to get the Senate, the governor, the House, all going in the same direction. Really made some big sort of bargains to get this out to you. It'll never come out again. So please, I'm begging you, do everything you can to get this over this time. Let me tell you what it does. It, number 1, says public use. You just cannot take it if it's not for public use, not public purpose, not all public use, which was never in the Virginia Constitution. Not that way. Number 2, you can't take more than you need. It sounds obvious, but in fact, there was a case in Hampton where they took more than they needed, and then instead of giving it back, they built that Bass Pro Shop on top with a 99-year lease. And so they basically were able to keep the property and give it from Mr. Ottafaro, whose property it was. There's a lawyer here who's going to correct me. Usually, there's no one here who knows more than I do. This time I'm wrong. Jeremy is the lawyer who knows everything. Do I basically right? You're correct. Okay. Can't take more than you need. The third thing is that the government has to prove it. Now, this sounds like lawyer talk again, but it's not. Right now, you have to prove it otherwise. Now the government will have to prove that it's public use. And the fourth thing is we're going to make it much closer to real value. Because right now, the compensation is not complete. It encourages these things, because why do they get all this trouble? Why does the government take it from one person and give it to another when they can just buy it? Because they don't get paid the going rate. Right now, you're going to hear from Mr. Wilson in a second, but in addition to not being able to take his property, they're not giving him what it's worth. It's cheaper for the developer to go through government to get them to take it and pay eminent domain than to pay the going rate. So the fourth thing is it fixes that issue. Now, I have a second half of the speech most of the time where I tell people what the real problem is, how this is not some ridiculous, airy-fairy concern we've come up with. You're going to hear from Mr. Wilson, and I've been using this all over the state. Norfolk has told us since 2007 this is not a real problem. We're making it up. This is something conservatives get to get themselves riled up, but it never happens. Don't mess with the Constitution. They lied. They were doing it. This wasn't Bristol that was doing this. This wasn't Roanoke, far away. Roanoke did it too. It was Norfolk. The very time they were saying this, there was no problem and no one was doing it. They were actually doing it. The very minute Mr. Wilson and his property, and I'll let him speak to the reasons why they wanted to take his property, not for a road, not for a school, not for a police station, but for a university village and a movie theater. It's obscene. It's absolutely obscene. So that's what the amendment is. Presumably, if you're sitting here, you're probably already very sympathetic to the idea that property rights are property rights. I just beg you to do everything you can to get it passed. The local Republican units are lining up behind it. That's actually pretty easy. We're getting some traction with local governments. We're up to 5. Albemarle, Hanover, Spotsylvania, Goochland, and just recently Prince William County have all endorsed the amendment and said all those local government groups against it don't speak for us. You can do a letter to the editor. There's still time. And then last, we are passing this petition. We're only doing this for another month. We send out messages and ideas on what you can do. So if you are interested in this issue, we just want your name and your email is the most important part. Sign it up and we'll send you information as it comes out.